The broadcast is now starting. All attendees are in listen-only mode.
but hi, we're having some technical difficulties, and we're back. I hope you were hanging in there. Today we're talking about the big meeting, and this is part 3 of our very special webinar series. And I'm here with Julia Frasca, who is one of the attorneys in our special education advocacy team at Littman Krooks, and I'm so pleased that she could join us today. So welcome, and I welcome everybody to this on behalf of Littman Krooks. Now, since we're starting late, I do want to say that I'm asked that you please hold all questions until the end, if possible, and if you want to replay this or replay any of our previous webinars because they all build upon one another, then please go to www.specialneedsnewyork and you'll be able to replay them. So today we're going to talk about the big meeting, but I just want to very quickly, if you don't mind, Julia, run through a quick review of for people that hadn't joined us previously, because one of the most important things about the big meeting is that this is a meeting where we have to work together as a team. There's a lot of members there, and it's really important that we at least start the relationship with the school district in a collaborative fashion. So if you've heard me speak before or present before, I always want to hit home that we don't want to always start in an adversarial fashion. I think that this is a business meeting where there's going to be give and take, and we sometimes, before going even into the meeting, we think things are going to be very adversarial. Now, Julie and I wouldn't have a job if it didn't get adversarial, right? That's right. But I just, just in the interest of preserving a relationship with the school district, we don't want to see terms like special education battlefield, the war to get services, and us against them at the beginning, because we want there to be a collaborative relationship, and there are some barriers to that, which I've spoken about over and over again. The parents and the district not understanding their legal obligations, and one of the things, by listening to this webinar series, you're becoming an educated consumer like Cy Sims and can sit at the table and speak in an educated way. There's limited resources, and even though it's a free and appropriate public education, of course there's that big school district budget that's sitting in the background. Also, we as parents have limited resources sometimes, and we look to the school district to provide services. Turf wars, I know with my child, and I'm sure Julia has 2 little kids, if anyone's going to tell her what to do with her little adorable daughter, then she would say, what are you talking about? She's my kid. But when you go to the doctor, you don't assume that you know everything the doctor knows. Just like there's a speech therapist and a psychologist and a special education teacher that went to school, to do these things. So but we kind of are, both the school district and the parents, we kind of get caught up in our turfs. And one of the biggest problems that we see all the time is coming to the table with a preconceived or predetermined program. I mean, how many people have been waiting for their CSE meeting, and you knock on the door and there's not a meeting in there before you, but everyone in there is going to be in your meeting, so what are they talking about? Where we as parents also, we want to prepare for this meeting, but we need to be able to go in with an open mind and listen and give and take. And even though we do preparation because we know what's right for our child, we do have to come to a consensus at that meeting. It shouldn't be predetermined. So in terms of building that relationship, understand that there's a mutual goal. I mean, especially with No Child Left Behind, I mean, your kid has to move forward. There's a shared responsibility in the education of the child. We can't just say, not it, and say, district, you have to do it all. We have to do some stuff too as parents. We have to have good communication. We do not want to wait till that annual meeting to say that there's a problem. If we have a problem, we know when we see that progress report, right, that you should be getting now, maybe. If not, if your goals haven't been started, or if there's, no progress seen, have a program review. Don't wait till the end. Whereas the district should also be letting us know in advance if there's going to be some sort of tremendous change in program. So there's an expectation when we come in to the meeting of what's going to happen there, a little, that what their plan is. And what you're doing, by listening to this webinar is understanding your legal rights and obligations. And what I always say is you may have a relationship with people for up to 21 years, and you don't want to start in an adversarial fashion. Now, we're not going to go over the IDEA in detail because you can go back and replay webinar number 1 where we talk about what the IDEA is and what Part 200 is. But I do want to just quickly say that the IDEA is the federal law. It's the law of the land. We in New York have Part 200. So when you're referring to something, it's the same, the IDEA, whether you're in Hawaii or whether you're in New York. And if you're in New York today, you know how cold it is. But New York has different regulations, and so you really want to be familiar with the New York regulations in order to advocate effectively. And I also want to go over a little bit, because there is a question of who is a child, and we talked about this in the first meeting. Who is a child with a disability? It's not just that diagnosis that's going to get you to that, to eligibility. You have to have that diagnosis, but you also have to need special education. And what that means is, if you have a child, let's say, for example, that has ADHD and can take the same test as everybody else, if they have preferential seating, or they have extra time, or their homework is broken down and they take frequent breaks, and they can come in class and do all these things, but they can take the same test, that's not going to be a student that would qualify under the IDEA and be entitled to special education. That child would be entitled to 504. Now, we have a future webinar completely on 504 because it is a tremendously misunderstood topic, but I do want to bring that up a little bit, because when we talk about the big meeting, we're going to talk about some of the requirements for 504 as well. So what are you entitled to? For 504, you're entitled to, first of all, free and appropriate public education. In the first series, you'll heard me talk about it being the best. It doesn't have to be the best. It has to be appropriate, and you have to understand what that means. In the 504 context, it's just education comparable to the education provided to non-disabled students. So it's leveling the playing field, basically. For the IDEA, free and appropriate public education means we need to have services specified in a document, the IEP, which we're going to be talking about a lot at our next webinar. Our next webinar is only about the IEP. It's got to look at the unique needs of the child. It's got to be free, and it's got to meet state standards. So if your child qualifies for an IEP or a 504, there are certain standards that they're entitled to a free and appropriate public education, and we discussed in webinar 1 what that means, and we'll talk about what the IEP document looks like, the individual education program, in the next webinar. So we talked a little bit about this, the 504 and the IEP process, and they look the same. They just have different things that go into each of them. Last webinar, I can't hit home enough, we talked about evaluations. You should not be sitting at the meeting that we're about to talk about if you cannot read those evaluations. It's like going in and not speaking the language. It's, I don't speak French, and if everyone started speaking French at the meeting, then we would not be able to understand each other, right? So if you don't speak the language, you cannot be an effective advocate. So if you missed the last webinar, please go back. It is our job as parents and to read these evaluations, to understand them. When a school district comes back and says your child's average, okay, and we know in our heart of hearts that our child is not average, you're probably right. But it sounds very different, stomping your feet on the floor, right, Julianne, saying, you know, my child, you know, of course they're not average. Don't you see how they are in school? Versus, you know, if you look at the subtest scatter and you see that in subtest number 1, the child got a 0, and then in subtest number 2, they got 100, well, of course they're average. What about that 0? That sounds very different than stamping your feet on the ground. And so unless you speak the language and understand what a grade equivalent is and an age equivalent and T-scores, Z-scores, canine scores, standard deviations, if you any of those terms are not familiar to you, go back and listen to our last webinar because you should not be sitting at the meeting. So that was your very, very quick review. And now we're going to talk about the big meeting. Julia, why don't you just tell everybody, you know, why do we even have to meet in the first place?
Sure. Meetings are necessary for several reasons. One can be determining eligibility or ongoing eligibility for your child. Another could be developing the 504 plan or the IEP. It could just be a program review. It could be a modification or change in placement. Or there could have been a disciplinary issue, so they had to hold a meeting to discuss that.
And you can have a meeting whenever you want, right? We're not just looking at the end of the year, you know, in terms of a meeting, right?
Yes. For example, if a parent chooses to have an independent evaluation that shows that there might be another issue or another diagnosis and they'd like to present that to the CSE team, the parent can do that, and then they have to schedule another meeting. And that can occur at any time during the year.
But we have to meet in order to develop the IEP or the 504 plan. There's got to be some sort of meeting of the minds, right, where
yes.
we all get together. So in terms of who has to be on that team, I guess 504 is pretty wishy-washy. Like, you know, and that's the whole problem in general. I mean, I'm glad we have a 504 and that people can access, but there's really no requirements where they lay out the people that have to be there, you know. So the districts are going to make a decision, you know, on who should be that 504 chair. It's usually a building person. All that the law really gives us is that placement decisions are to be made by a group of persons who are knowledgeable about the child. You know, the meaning of the evaluation data, placement options, least restrictive environment comparable to other facilities. There's no maximum, there's no minimum. There's actually no requirement parents be part of the discussion even at a 504 meeting. Technically, it doesn't even have to be a written plan, right? You know, so this is not, and this is why, you know, we like as lawyers to have an IEP, because we have rules of who has to be there and who doesn't have to be there, and we have a plan, and we have, and this is a building level plan, right? This is not something that travels with you, like from building to building. So if you're moving from elementary school to middle school, you need to have a new meeting, because this is an accommodation plan. It's not a special education plan. So how often should they meet, Julia? I mean, do they have any obligation to really meet at all?
The law does not specify any timelines. The best practices show that the plan should be reviewed on a yearly basis at least, unless if there's another issue requiring a reconvening.
Right, right. So at least yearly. So if you haven't seen your, you know, 504 committee for a long time, you may want to, and especially if we have to change buildings, right? Like we really need to meet, because it's an accommodation plan specific for the building, whereas an IEP, which we're going to talk about, or CSE, is not specific to a building. It's a school-wide plan. It can, and technically could happen in any building. So, you know, under the IDEA, if we're not in 504 land, we're sitting with this Committee on Special Education, the CSE. We're going to talk mostly about the CSE, you know, which is ages 5 to 21. We do have a few different rules, you know, for CPSE, the Committee on Preschool Special Education, but more or less it's the same. And the preparation should pretty much be the same. And that's specifically that Committee on Preschool for Special Education is only for ages 3 through 5. So there are required people that need to be at that CSE meeting. So Julie, you want to tell us a little bit about who needs to be on a at a CSE meeting?
Yes. And this differs depending on whether you're having a full CSE meeting or a subcommittee meeting. So for a full CSE meeting, the parents of the child, they should be given notice and they have the right to attend. the child when appropriate. If it's an older child in high school, the parent might want that child to attend because they can contribute useful and helpful information. A regular education teacher must be in attendance, a special education teacher, a representative of the school district, such as a CSE chair, someone who can speak to the results of any testing that was done, so an evaluator, a psychologist should be there. New York law requires that a school psychologist be present. A parent member must attend if the parent has requested the parent member 72 hours in advance, and a school physician also if that parent requested 72 hours in advance. So the parent member and school physician will only be there if the parent makes that request in advance, and that's something that they should be notified.
Right, and they should be notified in the notice of that. And I just want to stop for a moment and talk about the parent member, because I think there's some misconceptions about the parent member. This is not a parent advocate. This is a parent member. They are there as a representative of someone in the district who's also receiving special education services, a parent in the district that can help the parent understand what's going on in the meeting. It really depends on your comfort level with that. I know that when parent member was required, a number of years ago, I know that Julie and I would dismiss them because, I mean, I hate to use the word, but they're a crapshoot. Like, we want to know what people are going to say, and we don't know what this person is going to say. So I always recommend that, a parent member is not a bad idea, especially if you know it's parent members. But again, if you don't know this person and they don't know your child and they have an ability to be part of a committee, this is not, or if they're there as you are as a parent. So just think about that, but as a parent, I definitely recommend you become a parent member, because becoming a parent member, you get to know the CSE a little bit, the people, your chairperson. You also get to learn a lot. And it really shows that, you're willing to give back. I do myself try to serve at least once a month as a parent member. I do have to specify to the parents I'm not coming in as a lawyer, but I do do it because I feel that it's, a good way to keep the relationship going. Also, in terms of bringing your child, Julia is so right. I think when we're talking about transition, it's always important to have that child there. I mean, one of the things that, when we talk about transition, should be on every IEP for a kid in transition, even depending, it doesn't matter about their functioning level, is self-advocacy and understanding who they are as a learner. And unless they can do that, because the adult world is so different, it's going to be difficult for them. So I always tell parents who are kind of keeping it a secret, that their child has a disability because maybe they're in the mainstream, this is the time to fill them in and maybe have them come. Younger child, it's really hit or miss. I always say it's that kid's best day when they come to the CSE. My son, I have a son, for those of you that don't know me, I have a son, Aaron, who has severe autism, and when he was a little boy, he got a lot of services. And the CSE didn't, CPSE at the time, never really met him. They got the results of all the testing, but one day I was walking to drop off some paperwork at the school district, and there was the CSE chair. And she said, and if she's listening, she tells the story to everyone, is that Aaron? And I said, yeah. He looked right at her and said hello. And this is a kid that had no language, or very little language, no eye contact. I just had this entire meeting. And she says to me, I hope that's not Aaron. So that's what, in terms of keeping your, having your child, there at the meeting, it's hit or miss. In terms of a regular education teacher, a lot of people ask about that, why is that person there? A lot of times districts have the gym teacher there. It really should be a regular education teacher of that child, or a regular education teacher that teaches in that particular grade. If the child is having, physical therapy issues, maybe the gym teacher is appropriate. But, you do want to really look at that list of people, right, Julia, and make sure that the people at the table can contribute. Because sometimes you have general education teachers that are sitting there, kind of why am I here? Because they have really nothing to contribute to the meeting. Also, whoever the CSE chair is, you have to make sure that they have decision-making authority. I find that sometimes, you know, a school psychologist is appointed the CSE chair, which is fine. You can have dual roles. But if they have to go and ask their boss if they can do something, then they're not the CSE chair, and that's not appropriate. You want someone that can make decisions in terms of programming without asking permission. So who else should we bring to the meeting, Julia?
Well, a parent has a right to invite anyone that they would like to attend the CSE meeting, including people who have knowledge about the child or special expertise. For example, if the parent hires a private speech and language therapist to come into the home and provide additional services to the child, the parent may then ask that speech and language therapist to attend the meeting with them.
Right.
So the list could include doctors, tutors, therapists, etc. However, if the parent would like to take an attorney to the meeting, they have to provide advance notice to the district, and then the district has the opportunity to bring their attorney to the meeting.
So that's the obligation. You know, parents can really bring anybody with them, but if you want to bring an attorney, you have to tell them. And parents are important. They are part of this committee. That's why you have to be educated. I mean, I can't tell you how many parents don't feel that they have a say at their CSE meeting. You're just as important as any other member that we listed on that committee, correct?
Yes.
Yeah, and it's really important that parents do that. I mean, the CSE can proceed without a parent, but the district has to show, you know, a million different ways that they tried to get that parent. It's that important, and that the law really hits home, especially with all of its notice requirements and procedural safeguards and things like that, that the parents are part of this and that they know they're part of this. So please, you know that you are not someone that just has to listen. You're there that should contribute as well. Now, we're not going to go into too much detail because there's a lot on this slide, but Julia referred a little bit to a subcommittee, and a subcommittee can really do everything that a CSE can do. It just doesn't require as many people to do it. For instance, you know, I've had subcommittee meetings where it's me, a special education teacher, and the school psychologist that's also the CSE chair and the person that can interpret the results. That could be a subcommittee meeting. Whereas if it was a full committee meeting, it would have specific people that have to be there. The difference with the subcommittee meeting that I really want to hit home is that the only time you cannot use a subcommittee is for initial placement in a special class, in a class outside the student school attendance, or a school primarily want to hit home that it's an initial. But what happens if you have a subcommittee meeting and it's, you know, so you're at a subcommittee meeting, Julia, and you it's not an initial placement, you know, to another, you know, it's not an initial placement, and the district does something that you disagree with. I mean, do you have any particular rights if you have a subcommittee that you wouldn't have if a CSE made that decision?
Yes, the parent can disagree with what the CSE has decided. So the parent doesn't have to go along with what everyone else is saying, and they can actually submit a written a letter saying that they disagree with what the district has recommended, and they can request reevaluations.
And what about, though, in terms of a subcommittee in particular? If you have a subcommittee and you disagree, they do have to have a full CSE.
Yes.
So that's there is like another hoop to run through, and I don't think parents know that sometimes, that because subcommittees are used a lot, and I don't think you realize if you disagree with that subcommittee decision, you can ask that you have, before an IEP is implemented, you can ask for another whole meeting, like with the CSE, that's a popularly constituted CSE. So we do have, so a subcommittee, while it can do almost everything a CSE does, if you disagree, you do have another hoop to kind of, if you let them know you disagree, you have a hoop to kind of go through, which is good, a good hoop to go through in terms of getting a full CSE meeting. But again, Julia said, you know, you can always disagree, and we're going to talk a lot about that in future webinars and how we do that. So in terms of notice, and we're all about that in the law, like parents don't concern, in like real life, like no one concerns themselves with this. We live for this as lawyers. Like that's like law school 101. Like how many days do you have to do everything? No accommodations allowed either. I try to tell people all the time, you can't get accommodations on the LSATs because you can't say to a judge, oh, I know it's 10 days, but please, I need accommodations and I need to give me 15. Like, so, we have notice requirements. So for the meeting, what are those notice requirements?
The meeting notice is 5 calendar days. So a parent must be given notice in writing that there's a meeting, that there will be a meeting 5 days before. There are exceptions to this. For example, when a parent and school district agree to meet sooner, or when the purpose of the meeting is to meet timelines related to suspension or removal of a student for disciplinary reasons, the meeting notice may be provided less than 5 days before, or the parent could be asked to waive the 5-day notice, and they can do that.
And they also, usually that's not what happens. Like usually we get a lot of notice for meetings, which is good. But technically they only have to give us 5 days notice, and it can be by regular mail. Like it doesn't have to be electronic. So just realize that when you're getting that month in advance, that's a good gift we're given, and it's a good thing. So, the notice is pretty specific, and I'm going to have Julia run through the requirements of the notice, because, you really want to make sure that what it says in the notice is going to happen. The worst thing in the world is that you expect something and you expect people to be there, correct? And then you're there and you're talking about graduation when you were supposed to be there talking about next year, and what that means, and they'll meet, and you really need to look at that notice so you can relate back to it if the district tries to change the purpose of the meeting, or if all different people come that you didn't expect, right, Julia?
Exactly. The meeting should not be a surprise to the parent. The parent should be able to be prepared to know what to expect. So the notice has to provide the purpose of the meeting, the date, time, location, names of the persons expected to attend.
And what about that? I mean, tell about the people that are expected to attend. Like, are those the people that have to be there?
If it's a full CSE meeting, then the persons that are required by law have to be there. So
and if they list a name and another person comes in, like, is that problematic, or? It could be, right?
Because the person has to have knowledge of the child. They have to be able to attribute something.
So you need to, that's important, because, this is something little where you see, it says a special education teacher. It may not list the name of the person. If for some reason the special education teacher that knows your child is out that day, I wouldn't move forward with that meeting if you show up and someone that you've never met before is there, right? So that's why you have to pay attention.
Other things that the notice has are a statement that the parent has the right to participate as a member of the CSE or CPSC team, and a statement telling the parent that they may bring anyone to the meeting who has knowledge or special expertise about the child. It also has a statement of the parent's right to ask the school physician to be at the meeting of the CSE. And this does not apply to parents of preschool children. Again, the parent must request that the physician attend in writing 72 hours before the meeting. It also has a statement that the parent may request a parent member to participate, and they also must request that the parent member attend 72 hours in advance.
So everything's in that notice. I mean, so if you want that parent member or you want that school physician there, it should be in that notice that you were given an opportunity to know that. And there's more requirements.
So if the meeting is a subcommittee meeting, a statement that the parent may make a written request to the full CSC if the parent disagrees with the recommendation of the subcommittee, and this is what we were discussing before. The notice will also say that for students for whom a meeting will be held to consider transition services, a statement that indicates the purpose of the meeting and that the student will be invited, and lists any other agencies that will be invited to send a representative.
And sometimes the student will be invited, but that means mom and dad, you better tell them, about it, because they don't get a separate letter, typically, the student inviting them. They're usually, so that's really up to the parent to do it. Sometimes the school district will do it, like they'll see them, the school psychologist will say, come to the meeting, and sometimes we just maybe have them in at the beginning of the meeting. And then when we talk about specific services, they're excused. But, they are, especially with transition, the law, really, like what we said before, this is not something that Julie and Cheryl made up. It's important. The law says it's important students there. They actually make, a specific notice requirement about that.
And if I can give an example,
Yes.
I attended a CSE meeting for a child in high school where we were discussing transition services, and he had a hearing impairment. So they had someone come in from the state that could help him find a placement where they can help a student with hearing impairment develop skills and be prepared to enter the workforce.
Right, and so they can actually, right, and that's what they should be doing. So if there's transition activities, and when we talk about transition, there's a whole webinar on that in the future. They have to put together this coordinated set of activities to move the school from school to post-school. They may be calling in, different agencies, like here in Westchester, we have ARC and Westchester Disabled Youth that are better at it. And this, a school district knows how to teach, but I'm not sure they're as good if they don't have a life skills class and teaching life skills or living skills. So they may, or job training skills. So we may be bringing in, vocational trainers and things like that. So you really need to pay attention to that, because a lot of times parents say, we didn't know, that, transition started at 15 and that it needed to be in the IEP. And I never blame parents. We only represent parents. We love parents. But sometimes I say, goodness, it's right in the notice. And, I know we're overwhelmed as parents, but you've got to read these things. I know you get them a million times and you throw them away. I do. I feel like I have more procedural safeguard notices. I could wallpaper my house with them, okay? But I do read them. Outside of being a geek, I do read them because they're important, and I want to make sure that I understand they're, if something shifted, or if, they're doing what they need to be doing under the law. So read that notice. So, oh, we're talking about transition. That's the purpose of this meeting. I need to start thinking about that, because we need to talk about that.
Mm-hmm. And one more thing with regard to preschool students, the notice must have a statement that the parents have the opportunity to address the CPSC in writing or in person.
Right, and that's, they have some extra things for children with, with preschool, some extra things that we put in place. So we also have, something that is relatively new. It's called prior written notice, which means that even after we have this meeting, usually before the IEP comes out, and we'll talk about this a little bit later on, and so I'm not really gonna run through this in detail, is, we need to inform the parents, like, we are making a big shift here. Okay, and you may have not, you may have thought that meeting was just a program review, and then you find out they're bringing you back to the district. So there's this other notice that's going to come out, usually along with the IEP, kind of saying to you, parents, this is going to happen. So just know that that usually happens, after the meeting, but it can happen before if they're going to ask you for consent. And again, we don't have to necessarily run through every detail of what prior written notice says it has to say in it, because the New York forms are pretty clear and they do what they have to do, but you need to read it. That's all. I can't tell you how many parents say to me, I thought I disagreed, with the IEP, and they moved them anyway, or they gave me this IEP and saying they were going to move it, and you say, well, did you get this prior written notice that was going to happen? And maybe we should have said something before it happened. So just read what comes in the mail. Don't just run to that IEP and say, oh, I got the class, I got the whatever. Read these notices, because sometimes I've seen prior written notices where they talk about, I just had a client in yesterday where they talk about, what other options were considered, and they say, we considered other options, where absolutely they didn't consider options at that meeting, and of course, so that's why you need to look at that prior written notice. And again, I don't want to run through a lot of gobbledygook about what needs to be in that prior written notice, but you need to, well, I really want to hit home to you, and you can hit replay, when this goes on Special Needs New York if you really want to read through this, but this is what's on the forms. This is what the school district gets trained in as well, so you can go back and read that on your own. Again, procedural safeguards. We talked a little bit about this. The district needs to tell you that you have rights, okay, and you need to take a look at this, okay. Again, not, we've seen them a million times, but sometimes they changed. I think recently they changed what needed to be in the procedural safeguards, and there's different times when you need to get them, and I believe you need to get them once a year. Like if you have a child, basically if you have a child that's been in the same setting, for years, but still is an IEP, you have to get it every year. So you should be getting this every year. Okay, and you should be looking at it. That's all we're going to talk, because again, the form is a form, and we have IEP Direct, and we have companies that are pretty, that New York State schools use pretty uniformly, and they have usually what needs to be in there, but you have to, when there's a fill in the blank, that's when you have to really worry about it, and you should really read it.
Yeah, and if I could
yeah, please go.
The procedural safeguard notice could be intimidating to parents because it's a pretty large packet and it's very detailed. So that's why I think it's very important for parents to seek an attorney or an advocate to help explain the process to them.
Right. It's very, very important. And really, in preparing for a CSE or 504 meeting, and we're going to be talking about the breakdown of the IEP and what you're actually going to be, and we will be talking about exactly what you should be talking about at the IEP meeting in terms of developing that document, present levels of performance and goals, and using the evaluations to develop and the different reports from the teachers to develop a program and how to build goals next time, okay? But what we do want to tell you is one of the most important things is just be prepared. You cannot go to the meeting without speaking to the providers, without reading the evaluations, without having discussions with the team members about how things have been going. We're not saying, recommend a program, because again, that's not going to happen. But you need to talk to them beforehand. You just do. You have to read everything beforehand. It's really important, because you're a member of that committee, to develop goals and accommodations. If it's a 504 plan, collaboratively. I mean, in terms of the special education child, you are part of that team, and you should be a meaningful participant in that team. So if you say to me, Cheryl, I've gone to 20 CSE meetings, and we have never talked about goals. Well, I would say, well, maybe you've talked about them beforehand, okay? Or maybe you asked for drafts of the goals, and if no one wants to talk to you about goals, well, then you need to say, if you don't have time, I know you're rushing, you have 20 other meetings, right, Julia, but we'll come back, because you need to be part of that, because those goals are what we're looking at as lawyers when there's a problem. Okay, if it's not within the four corners of that document, so when that parent, and I tell this story, this very exaggerated example all the time, the parent comes into my office, they hate the school. The school's not doing what they're supposed to do according to the parent, right? They're angry, they want out, they want private school, they want change, and I open up the IEP, and then, well, first I say, why? Right? Why? What's going on here? Like, this is a great school district. And they say, well, Aaron, I'll use Aaron's name, is tracing the letter A over and over and over again. And he learned that in kindergarten. He's in 3rd grade. And I'm like, gosh, that's terrible. So, Julia, what is goal number 1 on the IEP of that child? That she's laughing, okay, if you could see her face. Because she knows what goal number 1 on Aaron's IEP has been for the last 3 years. Tracing the letter A, okay, right? So the district is actually doing exactly what you contracted with them to do. So, again, we don't blame parents, okay? But how did we miss that? Like, how did we miss that the district is working on something? Now, maybe Aaron switched schools. So he was in a kindergarten program somewhere else, and then in 1st grade somewhere else, and in 3rd grade somewhere else. That teacher doesn't even know that they worked on it maybe in the other school. I don't know. But it's so important to develop goals, because things will happen without your knowledge, and we have districts that we see the same goals every single year, and that cannot be. Like, if a goal doesn't work, we have a new goal. So goals can be modified. So we're going to spend a lot of time talking about that, when we talk about developing the IEP. But, I mean, collaborate.
Yeah, so it's very important for parents to ask lots of questions, be informed, and point out issues with the IEP. Because sometimes from one grade level to the next, there's no communication. There should be, but sometimes there isn't. So the parent can be very informative about what's going on with that child.
That's true. All right, stop. There should be a big giant stop sign here, okay? Do not meet under any circumstances if you don't have the information, okay? There is no way that we can have a reasonable conversation at the table if we do not have the information, okay? The evaluations, you know, any informal testing that was done, if it's the school year, you know, a regular, not a triennial year where we're doing evaluations. You are a member of this committee, and you cannot meaningfully participate without this information. So if it's 5 days before your meeting, let's say you've gotten the normal notice, which, you know, it says it has to be 5 days, but let's say they've given you 3 weeks. It's 5 days before the meeting. You shoot the district an email. You know, I need those reports or I'm not meeting, okay? You cannot sit at that meeting just seeing all these things for the first time. Better you don't meet, right?
Yes.
Better you don't meet. Because how can you be a meaningful participant if you don't have the stuff? And, you know, I'm going to have Julia talk about this because Julia loves to have pointers in front of her. I just learned that today. So, so if Julia were going to her own CSE meeting, I know that she would have one of these documents in front of her.
Like bullet points and lists.
Bullet points and lists, okay? And why do you have that? So when you get distracted, right?
Yes, it gives you sort of like a guideline as to the things that you want to bring up because you could forget. You know, you get nervous. You know, something gets brought up that takes your attention away from what, you know, what was on your agenda. So you want to make sure you cover everything. So things that are helpful to bring to you with you at the meeting are bullet points on what you want to cover. You could bring in a written agenda or a memorandum or a list of what you want to cover. You can refer to this list at the meeting, and it will prevent you from getting sidetracked. Yeah. And sometimes the distractions are set up by the district.
Right.
You know,
yeah. So it's very important, and you know, and we know because we both have adorable children that the minute someone talks about our kids, we're lost. Like, you know, I mean, we're lost. Like if they talk to me about Aaron, you know, I'm crying. You know, and it's very important. And my dad, who's a physician, used to tell me all the time. Whenever you go to the doctor, bring a list of what you want to say because it's so important. Because when you're sitting there naked in front of the doctor, you're totally going to forget and then try to get that doctor after. This is before there's email, you know. This is in the ancient times when you have while those, you know, the pink, right, me too, while you were out message. So I always use that same thing when I go into a CSE meeting. You want to make sure that you get back on point. This is a business meeting, and yes, our children are delicious, but that's not the point of the meeting, okay? And it's hard. We get kind of sucked into it. And I have to tell you, I'm not going to say, I can be an incredible advocate at anybody's meeting. I think I'm a pretty good lawyer. Ask anybody that sat in on a CSE meeting for Aaron if I make 2 minutes without hysterically crying. So this is not easy when you're talking about your own child. And this is really important too, like in terms of the spirit of collaboration, you know, yes, you only have to let the district know when you're bringing a lawyer, technically. But
if you have new information to share, so for example, if you disagree with the district's evaluation and you've gone out and gotten your own evaluation that has important information that says maybe the child requires more services than what the district is offering, or maybe there's a new diagnosis, you should give that to the school in advance. So that it's not a surprise for them and so that they can maybe prepare to offer some new additional services that they wouldn't have offered previously.
Right. It's very important. And also, you know, it's if you want them to be able to make a decision based on that information, it's the same thing like you getting the evaluations beforehand. Are they going to sit there in the middle of the meeting and read the doctor report? You know, I don't know. So you have a better chance of them relying on it and not just considering on it because they have to consider it. They don't have to rely on it, correct? Exactly. Unless it's their own report. And I've seen parents, and I believe that WIHD has a nice form for this where they have a parent report where you can talk about and submit. So if you think you're going to be really nervous about going in, this is what's worked last year. This is what hasn't worked for us. And so we have a writing, which is always really good, you know, to have a writing. But the parent talks about, I saw this kind of progression, and I see this at home, and I don't see this at school, so he's not carrying it over. Nice if it's in writing, you know, and then there's no he said, she said, right? So if you're bringing anyone to the meeting, you know, not in the lawyer, when, you know, if they're going to need an extra, if they're going to need a cafeteria, if the Italian family is coming, Julia always talks about her big Italian family, they all come. If Julia's family is coming to a meeting, we need a bigger room. So we did that, you know, in terms of that, you know, if you're going to bring a videotape, right, you know, yeah, just have them prepared. And I've had parents say, oh, I brought a videotape, and they, you know, if they weren't prepared to watch this and it was an hour videotape of your child, I mean, they'll watch it. Maybe they'll watch beforehand, or maybe they'll schedule extra time or get a bigger space or have the audiovisual equipment. So you just don't want to set it up so that you're fighting, right? Again, we wouldn't have a job if, you know, but we always see tips that we would, you know, if we could do it a little bit differently as a parent, you know, maybe we would have told them the 20 people were coming to the meeting instead of surprising them. So important is knowing the lingo, and we have a link on our website, Special Needs New York. It's a blog post I may have prepared, and you know, if you email after this meeting, we can direct you to it, but we give you a list of the, you know, what these things mean. You know, when they use CSE, alternate assessment, IEP, you know, there's all sorts of triennial, you know, there's just age equivalent, grade equivalent, just, you know, so you know, what do these acronyms mean? So that's really, really important. You know, like we said, you got to understand the tests and how they're reported. You know, make sure you've reviewed everything like we said, and we're going to talk about this next at the next webinar, but please make sure you understand your child and who they are as a learner and have read that last year's IEP, you know, have read those progress reports. I'm just as guilty, you know, of seeing those progress reports for the, you know, they get to the bottom of my pile, you know, and then I can't find them. You know, so make sure you know, read and understand the IEP, the progress reports, come with an open mind, you know, ready to make suggestions, think about bringing the student to the meeting, and you really can't be an effective advocate if you don't speak the language and know your child inside and out. I can't tell you how many times I have come up with goals, not because I'm super duper lawyer, because I'm super duper mommy. And I know how my son learns, and the district and the people sitting there are grateful. Like, they're not looking at me like, oh my God, like, here's the goal that Cheryl's coming up with. They're saying, oh, that really makes sense. You know, and that's not, and then people say, I want to see a list of goals. No, no, no. You know, goals are unique, and we're going to talk about next time developing those goals. And this slide is my favorite because we have so many roles as parents at the meeting, so many roles, okay? And you can just look at that, you know, so many roles. If you don't feel comfortable, you may want to bring someone to the meeting to help you. That doesn't mean necessarily Julia or myself or an advocate from our office. We have advocates as well, but not necessarily. Bring the person that's going to be able to speak when you start to cry. You know, bring the person that's going to keep you on track. Bring the grandmother. Bring the husband, the wife. You know, make sure that if you can't do one of these roles, that someone is there. And we do talk about, you know, and we, you know, tape recording sometimes if we don't, we can't write things down. We always get a lot of questions about whether that's good and what's bad, and we can, you know, answer that during the IEP webinar. But if you can't, you know, write everything down, maybe you're going to tape record. If you can't, you know, advocate because you're hysterical, you know, which is me at these meetings for my own child, not if I'm at your meeting. Don't worry about that. So then, you know, I need to bring someone that can do that for them. And after the meeting, we just have a few tips.
So basically after the meeting, you want to remember that this was a meeting to focus on your child and to develop a program that's appropriate for that child. And that should be the unified goal of this meeting. So be cordial. Thank everybody for their time and effort. Even if you disagree, it's always good to be cordial and have courtesy. You can then ask to see a draft of the goals in writing. It's always good to review those afterwards because something might have been mentioned at the meeting that didn't actually make it into the IEP, so that's important to be revisited. So ask to see a draft of the IEP or the 504 plan before it's finalized, and then write a letter confirming what occurred, and if you disagree with the program, make sure that you put it in writing.
Everything in writing. Now, you know, if you had a very good meeting and nothing major changed, do you have to do all of these things? Probably not. okay? Make sure you read the IEP when it gets to you, you know, to make sure. So I'm saying, do we always write a letter confirming everything that happened? If nothing really changed, I don't know. You know, we're just kind of putting it out there for you. And I always put this slide up there because this is where you're going to get a lot of information. And I just want to remind everyone that this particular webinar, because I'm seeing a lot of the questions that are coming in, have to do with getting ready for the meeting. Okay, and who needs to be there and what you need to do to prepare. That our next webinar on, you know, building the IEP, and then the webinar that's going to be coming up when we talk about what to do when you disagree, we're going to be talking about a lot of these questions that have come in where, you know, we have the right to independent evaluations, and then, you know, how do we challenge if a district doesn't allow that to happen. You know, it's... yeah, so we can't answer specific questions that have to deal with you know, specific circumstances, especially when things have already become adversarial. And a lot of the questions we're seeing, you know, things have become adversarial, and this is not maybe something you can do on your own, because this, you know, I see some of these questions and it really looks like the district is acting in bad faith, and I'm really sorry to hear that. One of the questions, though, that I think is very important is, where do I get parent member training? You know, parent member, you have to ask the district. Say you want to volunteer to be a parent member, and they will, you know, let you know if they need any more. They may have enough. Used to be a time when they didn't have any. But you can also access the parent member training at WIHD. There is the Special Education Direction Center there, and that's who does the parent member training. So if you call over there, I think you can just attend, whether you're being sent by your district or not. If there's a fee you would have to pay to go. And we do have a question also about if you want to get an out-of-district placement. That's beyond the scope of what we talked about today. When we talk about what to do when you disagree, what to do when you can't, you've tried all of these things, you read the IEP, you understand, we've tried to go back to meetings, and if we're going to, you know, private school reimbursement type of cases, which make up a big part of our practice, because, yeah, that's when you need a lawyer. I can't teach you how to do that. Julie and I can't teach you how to do that. We can send you to law school, you know, but that's when you're going to need a lawyer. What you sometimes don't need a lawyer for is that initial meeting, or when, and you can do things collaboratively. And we knew the question would come, and I shouldn't have brought it up. I knew I brought it up. Is tape recording? You know, we have different opinions, Julie and I, on this, I think, but they both make sense. Of course, having a recording is good, because then there's no question what happened at the meeting, right?
Yeah.
But what happens typically when we record?
The negative, there are pros and cons to tape recording. I personally like it. If I'm attending the meeting and if I'm representing the client, I would suggest that they record, because you can always go back and, you know, hear something that maybe you forgot or revisit an issue. However, the school district is aware of this, that they're being taped, so they might be on their best behavior. The parent might be.
They're not going to be going out on a limb. Like, no one's going to say something that may, you know, may hurt their job, you know, if they're on a tape recorder. Also, what happens usually? The district records, right? So the district, if you record, typically the district's going to record. So, yeah, it does make the district nervous, but you also are going to be on your best behavior because they're recording as well. You know, if the
parent does get emotional, then the district might say that the parent wasn't being cooperative.
Right.
You don't want that.
You don't want that. Now, I'm not saying it's, if we're involved, and that's what I always say to, you know, what I said to Julia when we were talking about this morning. When we're involved, yes, we're already in that place where we're thinking like lawyers are involved, we're going to record, okay? But if you're going in without the idea that this is ever going to become, you know, something, I'd probably not recommend recording at the first meeting, maybe, you know, and that's up to you. Like, I'm not going to say either way. I've seen it backfire, you know, when that parent has done it without, you know, I wasn't representing the parent, but the parent came to us later on and wanted us to represent them in a due process. And one of the things that you have to show in the due process is parents being cooperative. Well, the district brought in this tape recorder where this parent sounded like a lunatic. Like, I hate to use that word, but it was so bad and so prejudicial. But it really showed that the parent did not, it really, I didn't have anything to counter, because I didn't have a cooperative meeting to give it. So that is a big deal. So we're going to just answer one more question. One of the questions, is there a place where we can see goals in order to help write them? No. I mean, there is IEP Direct, but that shouldn't be. But we're going to be talking about how to develop goals, I promise you, at our next webinar. So I just want to make one thing. I'm so sorry that we had technical difficulties earlier. So that's why we're staying a little bit later now as well. But we will email all of you who signed up, and you will receive the link for the replay. So you will be able to run this and look at it again, and get a copy of the PowerPoint as well. And also, we will have dates for the we will have dates out soon for the 2015 webinars, and as soon as we get our schedules together, we'll let you know. And they're all gonna build on one another. And if you want a list of the lingo, the special education terms, you can also ask for that when you reply to the email that you get from us with the link. And again, I wish we could answer specific questions, but that's not what, about your specific matters, but that's not what this is all about. But I'm hoping that Julia and I were able to give you a bit of a understanding of the legalities around a meeting and how to prepare for them. And any final words, Julia? Or
just to keep yourself informed, because you are your child's strongest and best advocate. You're everything about your child. So make sure you review all of the documents, you attend the meetings, and that you keep an open mind during the IEP process.
And we're so happy that you joined us today, and we hope you will join us at webinar number 4. I don't have the date on me right now. December 2nd, okay? And that's where we're going to be talking about goal development and the IEP document itself. So thank you again, and we'll see you then.
Thank you.
And have a great Thanksgiving.